Hello and welcome. Thanks so much for joining us today. My name is Julie Westbrock. I work for TrustPoint Inc. We are a trust and investment management services company. We act as a professional fiduciary such as trustee. Joining me today is Lauren Fink. She is an attorney with the law firm of Amundson, Boggio, and she specializes in elder law and estate planning. Lauren and I are on the advisory board of the Minnesota and Dakota's chapter of the Parkinson's Foundation. So welcome to part 2 of our estate planning series, where Lauren and I are going to talk about trusts and more complicated estate planning. So Lauren, talk to me about what is a trust? And how is a trust different from a will?
A trust is a legal tool that is kind of like a living, breathing will. So a trust holds your property. You are the grantor or the creator of your trust if we're using a revocable trust, which is a trust that you can change over time. There is someone appointed in your trust as a trustee. The trustee is the person that has access and control of the property that's held by the trust. And then there are beneficiaries of the trust, which are the people that are entitled to receive the beneficial interest of the property that's held by the trust. So the use and enjoyment of the property. The difference between a trust and a will is that a trust does not go through the probate process, and it's effective during your life. So with a will doesn't take effect until your death. So the person that you've appointed in your will doesn't have any control to manage your property during your life or during any period of incapacity, and a trustee does.
So Lauren, you mentioned a revocable trust. What different types of trusts are there?
There are a lot of different types of trusts. So there are revocable trusts are the ones that we probably most commonly see. They're a tool that's used in estate planning where you create your trust during your life, and it says how your property is going to be managed during your life, during any period that you're incapacitated, and then what will happen with your property after your death. There are also irrevocable trusts, which the revocable trust can be changed. It can be amended or restated or revoked. And an irrevocable trust can't be changed. An irrevocable trust is created, and then after it's created, you have no control to change what it says. An irrevocable trust is a little bit more of an advanced estate planning tool, which may or may not be appropriate depending on your circumstances. There are also testamentary trusts, which is a trust that is created after your death or can be created from a will. Those are typically irrevocable trusts, and you can set them. Probably the most common testamentary trust that we see are trusts for minors, where if I die and my child is still a minor at the time of my death, then here is a trust that I've created. And these are the terms of the trust, and here's who's going to manage the property. There are also special needs trusts and supplemental needs trusts, which is a special type of trust that is created for a beneficiary who has a disability or a special needs. Those trusts allow that beneficiary to receive property or an inheritance, and so long as the property is held in those special needs or supplemental needs trusts, it doesn't affect any asset-based government benefits that they may be a beneficiary of or recipient of. Another type of trust that we commonly see is an irrevocable life insurance trust, which is a trust that's used for estate planning purposes, estate tax savings purposes. So those are kind of an overview.
Great. And we've heard the term a lot, funding the trust. Can you talk about that and what does that actually mean?
Sure. So A trust doesn't control property unless the property is either titled into the name of that trust, or unless the property names the trust as a beneficiary. So if you establish a trust with your intention to use that as your estate plan, but then you don't do anything to change any of your assets, then the trust won't actually control those assets. And that kind of goes back to our conversation in our first session about probate property versus non-probate property. So if property is retitled into the name of the trust or funded into the name of the trust, then the trust governs that property and it's distributed according to the terms of the trust. If property is in your name and you don't have a beneficiary and you don't have a joint owner, then while you're alive, that property is not controlled by your trust. On your death, that property would still go through the probate process, because from the account ownership, we can't figure out where that is supposed to go when you're gone. So the probate process appoints a personal representative, and if you've executed a will, which you typically would in conjunction with the trust, you would execute a will that's called a pour-over will, which names the trust as the beneficiary of your probate estate. Then your personal representative puts that property into the trust for you because you didn't do it during your life. But also with accounts that are held jointly or that name people as beneficiaries, if you don't move that to your trust, those account designations, those ownership designations trump your trust and your pour-over will, because the beneficiaries are the ones that have the authority to collect that asset. So it's really important that in conjunction with the creation of a trust, you also review all of your accounts and make sure that each account is either going to go into your trust or it's going to pass to the beneficiary whom you would like to receive it.
So if I have a bank account that I want to put into my trust, then is it just me going to the bank and saying, I have a trust, I want to put my account into it, and they have the correct paperwork for me?
It depends on the financial institution. Typically, when you work with an attorney to create a trust, that attorney will either give you information to give to your financial institutions to correctly change the ownership or the beneficiary designations of your assets. With the example that you brought up, if you go to your bank and you have the intention of putting your bank account into your trust, each financial institution has their own policies and procedures for accomplishing that. But what's important to understand is that the personal banker that you meet with is not an attorney, and they don't necessarily know what the terms of your trust are or why, when, where, or how you would want to put that asset into your trust. So it is very beneficial to work with an attorney when you're establishing a revocable living trust, because they will give you asset by asset information on what to put into your trust and why.
So let's talk about the position of the trustee. What does the trustee actually do?
So the trustee carries out the terms of the trust. So within the trust, there are certain articles or provisions that say, during my life, during any period that I'm incapacitated, and then after my death, this is what I want my trustee to do. So the trustee's job is to perform those tasks. So during your life, you can be your own trustee. And if you're your own trustee, then you're typically managing your property the same way that you have been up to the point that you created the trust. Most revocable trusts don't have a separate tax identification number. Your tax filings don't change because you created a trust. Really, the difference that you notice is that now when you receive your bank statements on some of your accounts, it says the Julie Westbrock Revocable Trust instead of Julie Westbrock. A person who is incapacitated who's created a trust, the trustee then steps into a role that's very similar to the role that a person acting under a power of attorney would play, which is that that person is in charge of managing the assets that are held by the trust. Typically, the trust will say, during any period that I'm incapacitated, my trustee is going to make distributions for my benefit. Sometimes a trust might say that the distributions can also be made for your spouse if you're married, or for persons who are dependent on you. So if you have minor children, then distributions can be made for them. And that's the trustee's job at that point, to make sure that your bills are still getting paid, to make sure that if you are in some type of long-term care facility, that the bill for that place is being taken care of, and that you're comfortable and in a lifestyle to which you're accustomed. After death, then, the trustee's job is to gather together the assets of the trust, pay off final administrative expenses, and then distribute the assets according to the instructions that you've put inside of the trust.
So the trustee has authority over assets that are within the trust, and the power of attorney would have authority over any other type of assets that wouldn't be included in the trust. Is that right?
That's exactly right. So if you have retirement accounts, for example, 401ks, IRAs, 403bs, those types of accounts, those are assets that can't be transferred into a trust during your life. And the reason behind that is because of most of those accounts are tax deferred. You create that account, you make contributions to it, and you don't pay income taxes on that account until you start to take distributions, which you are required to do when you reach a certain point in your life. They just changed it to 72. With those types of accounts, if you were to transfer that property to a trust, then it would typically cause a recognition of all of those income taxes. So because of that, in addition to having a trust, if you have assets outside of the trust, which you usually are going to have, you also would want to have a power of attorney executed. And the trustee and the power of attorney can be the same person. Many times it's easy for them to be the same person, because then you don't have to remember who's wearing what hat, depending on what account you need to access.
So in part one, we talked about what type of person would make sense for a power of attorney role. Talk about what type of person might make sense for a trustee role.
Sure. So it's a similar skill set. It's someone who would need to be organized and responsible, and be a little bit financially savvy, or at least have an idea of what different accounts you have and how they need to be maintained. A trustee can be a family member, or you can hire a professional trustee depending on your circumstances. And again, the more complex your estate is, the more that it may be a better idea to have a professional trustee depending on the circumstances.
Gotcha. And that is a role that TrustPoint is willing to take on, and we do act as trustee on quite a few irrevocable trusts, but also like your special and your supplemental needs trust, because those do get complicated and can be a little more to handle than any one individual person might want to take on.
Yes, especially with special needs trusts. The trustee has to have some knowledge of what different government benefits the beneficiary of the trust may receive. So the beneficiary may be a recipient of supplemental security income. They may receive medical assistance or Medicaid benefits. And each one of those programs has asset restrictions to the beneficiary, and has things that funds can and cannot be distributed for. So if you have a family member who is acting as a trustee of a special needs trust, if they don't have intimate knowledge of what the special needs trust can make distributions to the beneficiary for, then that can risk that beneficiary affecting their benefits or losing their coverage because of the distribution that they received from their trust.
So because of the complexities of just the laws and the rules surrounding these types of trusts, it's really important to choose the right attorney that has this area as part of their specialty. Would you agree with that statement?
Yes, it's a good point. It seems like these types of trusts, well, it's just a trust. Anybody can create it. But they have to be carefully drafted to ensure that the beneficiary's benefits are not going to be affected. And beyond the drafting of the trust, the creator or the person who works with you to create a special or a supplemental needs trust also has to know that each jurisdiction, each state has different requirements for who can be the person who creates that trust for the beneficiary, what notice needs to be provided. So for example, do you need to notify the Social Security Administration that this trust has been created? Do you need to notify the Department of Human Services that this has been created? And then beyond that, how are taxes prepared and filed for that trust? And again, what distributions can be made, especially when it comes to Medicaid or medical assistance benefits is what we call it in Minnesota. Each different state, the rules are based off of the rules for supplemental security income, but each state has different interpretations of which pieces of those laws are going to be applied. And how it can be interpreted county to county sometimes can be very different and tricky. So it's important, if you have a beneficiary who receives those benefits, to work with an attorney who's familiar with how those benefits function. Because again, you're risking that person losing their coverage if you're working with someone that just is unfamiliar with the programs.
Great. So let's switch gears a little bit and talk to me about how a trust can protect my family or beneficiaries as opposed to a will.
Sure. So with a trust, when you're looking at how you want to pass an inheritance to your family or to your beneficiaries, many times we're able to say, well, I can just give it to them outright and they can put it in their bank account and they can do whatever they would like with it. But that's not always the case. Sometimes we have beneficiaries who, if they were to receive an outright distribution, they would not be able to handle it, either because they just are not good with money, or because they have some type of dependency on alcohol or prescription drugs or other medications, and receiving a bunch of money in their bank account is going to be a really terrible idea. So for those types of beneficiaries, what you can do is you can create a trust that the inheritance that you leave to them would be held in that trust. And rather than that beneficiary being the decision maker with the funds that they receive, you select a trustee. And that trustee would be the person who would decide when, where, why, and how the funds are distributed to the beneficiary. And in the trust itself, you can say, this is how much the beneficiary is going to get, either monthly, quarterly, or annually. And these are the purposes for which they can receive distributions. So you can put a lot of control over how they receive their inheritance.
Talk to me about what types of situations would you consider complex that would require more advanced estate planning?
So with advanced planning or with trust planning, if we have complicated family dynamics, that would be a circumstance where it may be a good idea to establish a trust. Complicated family dynamics would be blended families, or circumstances where someone is being disinherited, and we just don't want the administration of the estate to end up being an all-out battle in a public forum, such as a probate court. Other circumstances would be if you have a taxable estate. So a taxable estate depends on where you live. Here in Minnesota, taxable, we have our own state-specific estate tax, which as of 2020, the estate tax limit in Minnesota is $3 million per person. So if you have an amount over that, then you may need to pay taxes to the state of Minnesota, and trusts can assist you with tax savings or taking advantage of marital deduction planning. If you own property in multiple states, then trust planning is a really excellent tool to use. Not a lot of people realize that depending on if you own real estate in different jurisdictions and you have a will-based plan, then you need to have a probate in each different jurisdiction where you own property. So for example, for the snowbirds who have property in Florida and property in Minnesota, on your death, if you had a will for a plan, you would have to have a probate in Florida and a probate in Minnesota. And the estate administration's costs can be fairly expensive. Whereas if you establish a trust and put your Florida property and your Minnesota property to be titled in the name of the trust, then you only have one trust administration instead of those two probates. So it can cut down on expenses.
So I think it's important to note, and you made a really good point about even though the federal exemption is so high that each state may also have an estate tax. And so like you mentioned, Minnesota having 3 million per person. So it is important to factor in the state as opposed to just looking at that federal amount, because I think a lot of people do that. They think, wow, well, that's, it's 11 million some, and I'm never going to reach that point, so it's not going to affect me. But the state can creep in and surprise you.
Yes. And the federal exemption too, for married couples, the exemption in 2020 is $11,580,000. And if you're married, you have what's called portability. So what that means is that between spouses, you can share your unified credit towards gift and estate taxes. So all that needs to happen in order to utilize both spouses' $11 million credit is that on the death of the first spouse, you file an estate tax return. And then on the death of the survivor, they can use any unused exemption amount of the first spouse. So married couples can pass up to, $22 million without having to worry about the 40% estate tax that the IRS imposes. Minnesota, we don't have portability. So there needs to be special attention to using other estate planning tools within your documents in Minnesota or in other states that don't have portability and have a state-specific estate tax, so that you can make sure that at a minimum, if you're married, you're using your estate tax exclusion and that of your spouse's, and not paying any unnecessary estate taxes when you had enough exclusion.
And I think that's a good segue into how one could use charitable giving as part of their estate plan and tax plan?
Sure, yeah. So charitable giving, if you name a charity as a beneficiary of your estate and you have a taxable estate, then when the estate tax return is being filed for your estate, you can deduct the amount that is contributed to the charitable organization. So that's one way that you can reduce the amount of estate taxes that would be potentially paid to either the IRS or, if you're in Minnesota, to the Department of Revenue. With charitable giving, you get that estate tax deduction. Another consideration is, depending on what the assets you have, which assets you may want to give to charity. So for example, now we see a lot more people that have retirement accounts as part of their estate. So IRAs or 401ks, those types of accounts where it has deferred income taxes within the account. When you have a beneficiary who inherits a retirement account, those income taxes don't go away just because you died. That beneficiary now, if they take distributions from that retirement account, they are going to have to pay income taxes on those funds. So when you pass an IRA to a family member, you're not passing that whole account balance, because you're passing that account balance less taxes that would be owed on those funds. Charitable organizations don't pay income taxes. So if you have accounts set up where you've already paid taxes on those accounts, give those accounts to the family members, the individual beneficiaries who you want to leave an inheritance to. But on your IRAs, your 401ks, if you name a charitable organization, that charity gets a dollar for dollar benefit on those funds that they receive from you. So you get an estate tax deduction if you have a taxable estate, and the charity is not paying income taxes on that money. They get to keep all of that money, and that gets to be used for that charitable cause. So that's I talk with clients a lot about, if you have charitable goals, use your IRAs to accomplish those goals, because that money will be better used by the charity who doesn't pay taxes.
Right, and it sounds like it's you get the most bang for your buck.
Exactly.
If you're donating your IRA to charity, and you can designate just a certain percentage of your IRA as opposed to the entire thing. So if somebody did want to say, okay, 50%, I want to go to this charity, 50% to this charity, or 50% to this charity and 50% to this person, there is that kind of flexibility.
Exactly. Yeah. So, sometimes I'll work with clients and they'll say, well, I want to leave $100,000 to the Parkinson's Foundation. And then we'll take a look at their IRA and we'll say, well, you have a $200,000 IRA. Why don't we name the Parkinson's Foundation as beneficiary of 50% of your IRA? And then that's where that charitable contribution will come from. And then they can name other non-charitable beneficiaries, or they can just name all charities on the beneficiary designation. And the nice thing about the way that passes is that it goes directly to the charitable organization. It doesn't become so much part of the estate administration. And if your charitable goals change over time, let's say you get older and you think, I want to leave 100% of those funds to the Parkinson's Foundation. You call up the IRA administrator, you change your beneficiary designation, and that's all that you have to do to update that portion of your plan. So it can be really easy to change as well.
So if I have a more complicated estate or family dynamics or assets, and I know that I need more complex estate planning, what would my first step be?
The first step would be to reach out to an attorney and have a conversation with them about what your goals are and what your concerns are. A lot of times people think that there's kind of a one-size-fits-all estate plan, and that's really not the case. There are so many different tools that can be used within your own estate plan that you want to make sure that everything is really customized to meet what your goals are, to meet the family dynamics that you have and your family members, and that it's going to be a plan that's going to work with all those family members, that it's going to match the assets that you have. So if you've got those retirement accounts, or if you have a business, or if you have a bunch of different real estate, that the estate planning tool that you choose is appropriate for those assets. And then also that it's going to be something that you're willing to keep up and maintain over time, depending on how complicated it is, because there are a lot of really complicated estate planning strategies that we can implement, but they're not set it and forget it estate planning strategies. So, you know, a lot of times I also like to say, you keep it simple, stupid. You know, if you are not going to want to review your beneficiary designations every 5 years and make sure that things are still going into your trust, then a will might be a more appropriate plan for you, and just acknowledging that you might have more estate expenses on the back end because you don't want to put the work into your estate plan during life.
Right. So getting the right professional in place and somebody that you can work with over the years as your situation and your estate changes.
Yes. And nominating people within your documents that you trust and that are going to be able to carry out your plan, whether those are family members or whether those are professional trustees or fiduciaries.
Right. And that all can be discussed with the attorney. What options are available, who might make sense to name in those particular roles, and to give suggestions on, certainly on the charitable giving piece that we talked about, and what options might be available.
Yes.
So I think regarding the charitable giving, part 3 of our estate planning series will be about specifically charitable giving and the different vehicles that are available for those that have charitable intent. Thank you for joining us today. Lauren and I appreciate you tuning in and on this part 2 of our estate planning series, and hope to see you on the next one about charitable giving. Thanks so much for joining us.